So, Nick, anything else?
Yeah, I think just kind of also to close out, we had mentioned that a lot of municipalities are opting out just in anticipation of the rules. Now that they're out, do you kind of, obviously not urging them to or not to opt in, but do you have any kind of, words of wisdom as far as how they're to proceed now that the rules are out with the next 4 months? I know they have some time to digest that, but if any, going there now, having the rules in front of them, I know even with medical, sometimes there would still be, some criticisms that they weren't too fleshed out yet for them to feel comfortable to do that. But I think that, the adult use rule set is 64 pages, I think, and it's more significant than, a year and a half ago when the emergency rules for medical and then permanent rules came out. So do you have any kind of words of wisdom for municipalities?
Well, I think the thing I want to encourage more than anything is to start looking at things and determine what the best approach is for each municipality. Unlike on the medical side, there's not an opportunity to sit on the sidelines and wait. If we receive those applications, and we will starting November 1st, and there isn't a municipal ordinance in place at all that addresses this, then we're compelled to issue a license. So I think it's critical that every municipality takes a look at the rules and takes an approach to this. If they determine that the facilities aren't appropriate for their jurisdiction, they simply need to put an ordinance out there that says that. They always have an opportunity to opt in later. They can change their ordinances at any time. We just want to make sure that they've had a good opportunity to consider the state's approach to things, fill in the gaps where they feel it's necessary, and take the approach that's best for the citizens of their community. And when it comes to applicants for licensure, particularly those who aren't known to us on the medical side, I think it's important for them to look at the rules as well and understand what the conditions are for approval. You gentlemen represent a lot of applicants, so you know that getting an application perfected to the point that we can approve it is not necessarily as easy as it looks on paper. There's a lot of documentation required, and when it comes to passing an inspection, there's a regulatory inspection from our agency, there's a fire code inspection, you have to pass building code inspections as well. And that 90-day timeline, I think, was put into the statute to bind the agency to make sure we weren't dragging our feet. But in the end, I'm more concerned that it'll be a negative implication on applicants who have challenges if they're starting a brand new business to get everything we need so we can get them through the background check phase and get their facility into condition so that we can approve it. So we built in that two-step process that we have on the medical side as well. So I want to encourage new applicants who aren't already licensed on the medical side to submit that step one, get through that process, get your pre-qualification approval, and that way you have 90 full days to submit that step two application, pass all the inspections, and get your license. I don't want people to be denied at 90 days simply because they couldn't get the paperwork together in time. They couldn't correct some deficiencies through the inspection process and then have to reapply.
Mm-hmm. Yeah, and that's another, just to kind of add on to that, there was another feature I saw that was baked in there, pun intended, I guess, that it was a 5-day deadline to respond to deficiencies, and then there was a 60-day deadline to kind of have a physical facility and have it inspected and pass that. So it kind of it seems like you're creating these, not to say barriers, but realistically, I'm sure there are a lot of people that got step one approval just because so many municipalities decided to opt out. There weren't a lot of physical locations. So it's kind of almost seems like the MRA is saying, come to us when you're ready, make sure you have things and all your ducks in a row, and then apply, and then you have these deadlines to kind of meet. So make sure you have everything together, before you submit, so to speak.
Absolutely. I think, preparation is key. And reviewing, we'll put out the application well before we start accepting them. We'll put out checklists. We'll do presentations on how to work through the application process. But in the end, it seems very simple, I think, from the outside looking in to say, why would it take more than 90 days to process an application? But we have hundreds and hundreds of these on file at the same time. So, to get yourself in the queue and get it worked through, and everyone wants their application to be processed quickly. So if there's a deficiency notice that has to be sent, now you're working to the back of the line again. And when we're working against that 90-day time frame, we will issue denials if the application can't be approved at that 90-day mark.